Senator, a question about the Supreme Court. Everyone running for president always says, especially on the narrow issue of abortion rights, no litmus test. Right. It's said on both sides of the issue. And if that's true, if you're not going to call a future justice into the Oval Office, if you're successful in this endeavor and bring up the subject, how then do you also avoid surprises? I don't think George H.W. Bush, 41, ever dreamed that in Justice Souter he was appointing a dependable liberal vote. Right. And Eisenhower for years called Justice Brennan his biggest mistake in office. Two surprises that just come to mind.
Right. Well, look, I think that what you can ask a judge is about their judicial philosophy. And as somebody who taught constitutional law for 10 years and who actually knows a lot of the potential candidates for Supreme Court on the right as well as on the left, because I've taught with them or interacted with them in some way, I can tell you that how a justice approaches their job, how they describe the task of interpreting the Constitution, I think can tell you a lot. And so my criteria, for example, would be if a justice tells me that they only believe in the strict letter of the Constitution, that means that they probably don't believe in a right to privacy that may not be perfectly enumerated in the Constitution, but that I think is there. I mean, the right to marry who you please isn't in the Constitution. But I think all of us assume that if a state decided to pass a law saying, Brian, you can't marry the woman you love, that you'd think that was unconstitutional. Well, where does that come from? I think it comes from a right to privacy that may not be listed in the Constitution, but is implied by the structure of the Constitution. So I can have that conversation with a judge. Now, a conservative who was listening to me right then says, see, he's wants to allow the court to legislate. No, 99% of cases, the Constitution is actually going to be clear. 99% of the cases, a statute or congressional intent is going to be clear. But there are going to be 1%, less than 1% of real hard cases.
Second Amendment last term.
Second Amendment last term is a great example, where the language of the Second Amendment is not perfectly clear. I believe that the Second Amendment is actually an individual right. I think that's the better interpretation. You can make the other argument. And so I can have those kinds of discussions with a justice without getting to the particulars of is Roe versus Wade as currently outlined exactly what you believe, or do you agree that the D.C. gun law should have been overturned? And I think Senator McCain, if he ends up being the nominee, could have those same conversations as well.